All right, so the first ruling or the first session today deals with the Chevron roof or Loper Bright. We have two great speakers and appreciate the last minute step in by RAWalker to sit in. We had a couple speakers drop out, but the two that we have definitely know the area of federal regulation and state regulation on energy issues, environmental issues, all the different angles that are going to impact both state and federal going forward. And if it reshapes how we do work, what it might look like if things change both in Congress or during the or within the regulating system, what's that ultimate impact? So if with that, if I can call up RAWalker with RAWalker and Associates, as well as John Coyle with Duncan, we will get this first session started with just a short presentation to give you a primer if you're not familiar with Loper Bright and the Chevron rule doctrine. That John will be able to walk you through.
Okay. We'll need to go that way. Don't know why. But it was something that's a little bit inhumane, but you know. Oh, sorry. Struck me as a little bit inhumane. Starting at 8:30 in the morning with this, but you know, it's Central Time, so for me it's really 9:30. It's okay. We do have, oh, there it is, volume, wow, cool. We do have a little bit of legal nerdery to go through here. And I will try to short circuit it, but those of you who are looking for CLE, you have to have one of these to justify your CLE credits, so it's there. You don't have to pay attention to it if you don't want to, but let me see, where, how do I advance the PowerPoint? Just, there we go. All right, that's me and Roger. Okay, good. What's next? I'm not advancing here, Josh. Okay, great. Beautiful. All right, so this is your PowerPoint, and I will follow along. Sort of a short history of Chevron. Thoughts about judicial review of administrative law. An issue that really goes back, if you think about it, to the assassination of President Garfield in 1883 by a disgruntled office seeker, which provided the impetus for the establishment of a professional civil service in the United States, and created at least a century of relatively non-controversial rulings until you get up to Chevron in 1984. In quick summary, the idea of judicial deference to administrative interpretation statute sets up a level of conflict between the executive branch, Article 2 of the Constitution, and the judicial branch, Article 3. But that's just the beginning. Next slide, please. So you can follow the evolution of Chevron. It only took probably about 20 years for the notion of some kind of deference to administrative interpretations of the administrative agency statute to bubble up in the courts. And things bumped along pretty peacefully. You have the formulation of Skidmore deference that we'll cover in 1944, then the all-important Chevron two-step, which is the formulation that excited some hunting impulses on the bench in the local Bright case that we'll get to. And then almost as soon as Chevron was announced, the Supreme Court started having problems with the notion of deference to administrative agency interpretations of their organic statutes and started pruning Chevron in two, I think, significant ways. One in United States versus Meat Corp, where the court held that Chevron only applies to statutory interpretation that's involved in notice and comment rulemaking, doesn't apply to or doesn't merit any deference for administrative agency interpretations and decisions as opposed to notice and comment rulemaking. And then the all-important major question doctrine, which is a big exception to Chevron that became ultimately the exception that swallowed the rule. And finally, local Bright Enterprises, this term in the Supreme Court, found after 40 years that Chevron was inconsistent with Section 706 of the Administrative Procedure Act, which says that judges will decide what the law means, not administrative agencies. And you have to scratch your head and wonder a little bit why it took 40 years to figure that out, right? I mean, if something is really inconsistent fundamentally with the Administrative Procedure Act, I would have thought a bright bulb like John Paul Stevens would have recognized that back in 1984 when he wrote the Chevron decision. But there's a little subtext here. And part of that subtext is Stevens' comment, often overlooked in the Chevron decision. It says one of the reasons we defer to administrative agency interpretations of their organic statutes is because the administrators have a constituency and we don't, right? And that's an interesting sort of political science recognition that tended to get buried in a lot of this discussion. These are, summaries of the case law. Bates and Guild versus Payne is one of the earlier formulations. You notice 1904, we've only had a professional civil service at that point for 20 years. Okay. Skidmore versus Swift and Company was a Fair Labor Standards Act case, came up during World War II. And Justice Robert Jackson sort of gave pretty well, we'll do what the agency thinks is right if we like it and it's persuasive, and otherwise we won't. So we still have Skidmore deference, although to call what Skidmore calls for deference is a little bit ironic. We can skip Scheimer, and here we come to Chevron. Involving Clean Air Act Section 111, the definition of stationary source. The Clean Air Act has been one of the focal points of controversy over Chevron. But this is Justice Stevens' formulation of the famous Chevron two-step. First, you ask whether Congress has directly spoken to the issue. If it has, that's the end of the inquiry. If Congress has not directly addressed the precise question, then the court doesn't simply embark on its own construction of the statute, but looks at whether the agency's construction of the statute is reasonable and permissible. Okay? That's really what Chevron was all about. Next slide, please. Now, Smiley versus Citibank is a reformulation of Chevron, interestingly enough, by the great scholar Antonin Scalia. And this is really the formulation that Justice Roberts attacks in Loper Bright. We've gone from sort of, we'll pay attention to what the agency says, to ambiguity in a statute creates a presumption that Congress left the ambiguity there to enable the administrative agency to fill in the blanks. That would set the team of any Republican Supreme Court justice on edge. And it did, but you'll notice that this is now 1996. Chevron is 12 years old, approaching middle age for a court case. It is that presumption articulated in Smiley that becomes problematic for the court. Next slide, please. So, then we go through the various limitations on Chevron. Encino Motor Cars, Chevron deference only applies to notice and comment rulemaking where notice and comment rulemaking procedures are appropriately followed. Otherwise, you get no deference. Okay. And of course, the major questions doctrine. Again, there's our friend Justice Scalia saying, yeah, Chevron doesn't apply if the question is one of deep economic and political significance. FDA versus Brown and Williamson, where the court says, yeah, well, the Food and Drug Act is pretty broad, but Congress didn't give you guys the right to the power to regulate tobacco, so go try again. And subsequently, we had some legislative intervention in that, and now they regulate the hell out of tobacco. And then the Utility Air Regulatory Group, one of the big Clean Air Act cases. And this is really the formulation of the rationale for the major questions doctrine. And when an agency, and again, this is Justice Scalia, an agency claims to discover a long extant statute an unheralded power to regulate a significant part of the American economy, we typically greet that announcement with a measure of skepticism. Nothing wrong with that in principle. The case law goes on, King versus Burwell, the Affordable Care Act, West Virginia versus EPA 2 years ago, shot down the Clean Power Plan. Next slide. And then this was from one of my law partners, who did a version of this speech at the American Public Power Association Legal and Regulatory Conference a couple of months ago, pointing out this is a summary from Bloomberg by U.S. Court of Appeals who invokes the major questions doctrine. And what you can see there, if you follow this space, is that the United States Court of Appeals for the Fifth Circuit in New Orleans is a big believer in the major questions doctrine, and everybody else kind of goes, meh. So next slide. Local right comes along this term, involving a requirement imposed by the National Marine Fisheries Association that herring fishermen fund the presence of observers on their boats to keep track of the herring catch, I guess. And at that point, although people had anticipated the demise of Chevron for some time, this rather, frankly, not all that significant, not all that momentous a case, heralded the overruling of Chevron. And again, the idea is, well, it's inconsistent, it's contrary to the Section 706 of the Administrative Procedure Act, which, by the way, goes back to 1946 and is roughly co-equal with Justice Jackson's formulation in Skidmore. The 706 is quoted there as to the extent necessary to decision, and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. Now, that language didn't change between 1946 and 1984, and it didn't change between 1984 and 2022. And that's one of the things that has people scratching their heads about Chevron and local right. And I think that may be, two primary corollaries. Yeah, here we go. So, court was careful to say, we're not overruling anything that we did under Chevron. Those cases are still binding. And that Skidmore deference, which again was sort of a very soft form, will follow what the agency says if we like it. The early formulation remains in effect, remains good law. Do we have another slide? I think that's probably, there we go, that's it. All right, so that is the mystery of Chevron and administrative law. I think part of what you're here today to hear about is, well, okay, this is very interesting, Coyle. But, you know, what are the practical implications? And that's why Roger's here.
That's why we're both here.
Yeah.
Yeah, I wouldn't mind just jumping in and adding, you know, my 2 cents on all this. I graduated from Lewis and Clark Law School in Portland in '93, and, from Missouri. And I never anticipated coming back to Missouri when I went to Portland to law school, but I did. I got an LLM and a master's degree in law, so they tried to teach me more things than my head would fit. But I came back to Missouri and I clerked at the Missouri Supreme Court, and Missouri never adopted Chevron as you know, as authority. But we normally cite Skidmore. And then basically in Missouri, if you had a regulatory issue about interpreting a statute, you know, the agency would get some deference if their approach was reasonable. There's value to be considerable deference. I mean, they use the law, that's just what the regulation is based on. So you gotta give them some deference, and it's significant, not absolute. It's really more like the Skidmore deference, I guess, in some ways. And that's still the law in Missouri as far as I know. And yet when I remember writing some of these cases, you know, writing the draft for judges to look at, and I actually thought Chevron at the time, I mean, it came out in 1984, so this is 10 years, 12 years later. I thought that Chevron made some sense, and one of the things you don't hear about was, not really getting talked about that much, is the part of the reason for Chevron deference was, you know, we're a nation of 50 states, we have, you know, federal laws that apply across all these borders. And I think part of the problem is when you get different jurisdictions saying different things about the same regulations, and it makes it a little confusing. We may end up going back to that to some degree, I don't know. But that was sort of the premise for Chevron. Wasn't the only one, you know, I mean, it was also, it made judges' lives easier that if you could, you know, you didn't have to do a lot of the investigative research or your analysis with your clerks or friends in the court briefs or whatever to figure out what would be the right position. Now, and the other problem that led to Chevron, I think, was that Congress is lazy is not the right word. Congress is they don't really want clarity in most of the laws. You know, the Clean Air Act, Superfund, Clean Water Act, a lot of those laws wouldn't have gotten passed easily if they had the kind of clarification that some of the advocates for those national laws wanted. And even if they did provide more clarity, there's always gap filling. I mean, it is always the agency's job. The government would fall apart if you didn't have agencies gap filling, trying to determine what the hell the state general assembly or Congress meant. And so it was, you know, it was sort of left to them, A, to have some sort of a precedent that worked nationwide, and B, to put some boundaries on legislation that was purposefully left back. And then the problem came, it's like, okay, that's in the mid-90s, and I thought, well, that's kind of finish it. I mean, you know, it sort of made sense. You know, these guys worked with these laws, worked with these regulations, and why not give them some deference? It was never absolute. It was never that the judge couldn't, you know, do something different. But then I noticed, you know, I would say about 10 years later, in 2000s, primarily, maybe it's, at least for me, you hear comments from some folks who work at EPA or other agencies saying, not just using it as shorthand, well, we'll Chevron that. You know, using it like a verb, you know, with the understanding, you know, and you know, we may be stretching the limits here, but, you know, Chevron, you know, the judges gotta give us a lot of deference, and there's a lot of case law that says that that's the way it should be, so. And that's when I knew something was wrong. You know, I'm not a litigator, so I hadn't been active on the case law development, but you see it on the regulatory side, it's like, well, wait a second. Okay, And then, so, you know, I mean, I can understand why there's, you know, there's always this sort of this opposition among jurisprudence professionals and litigators about what that really meant, and then now all this case law kind of whittled it back. And it comes to the, I guess the final thing I'll say, sort of introductory, is that I've sort of come to think Loper makes a lot of sense. You know, it allows some deference. It didn't, you know, it kept Skid more. And I was listening, I read the remarks of, one of the, Supreme Court judges, Justices, Kavanaugh. He's speaking at Catholic University. It's like, come on, you know, it's, this is not the end of the world here. What we've done is, you know, sort of a correcting the ship sort of thing. And coming back to a concept that gives the agency some depth or some authority, but it's the judge's job. It's the American, you know, it's the Administrative Procedure Act, and it's the judge's job, and, you know, to determine what the statute says. And if they, and even now, if the agency makes a reasonable case for that, then, you know, that'll be listened to. So I really think it's kind of, we're coming back to where we started in a way, and I think it makes some sense, and I'll stop there and then throw over to John.
One of the observations that I keep hearing, I mean, there are two divergent schools of thought on what Loper really means for the future of administrative law. One is, oh my God, the sky is falling. You know, Chevron was a sacred totem of the administrative state, and these crazy conservative Supreme Court justices are busy tearing down the edifice and blah, 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 blah. And then my friends at the R Street Institute go, so what? You know, all Chevron ever was a decision-making modality that allowed judges to do what they want. That's a cynical view, but I am a cynic. And I do kind of, with a couple of reservations, sidle over to the R Street Institute's view that at the end of the day, this doesn't make that much difference because wearing that black robe is never having to apologize, right? Do what you're gonna do, you call the shots, that's what you took the oath to do, boom. Doesn't matter what rubric you do with them. I think, though, that there are a couple of practical implications, and I'm fascinated to explore these with Roger, because we didn't get a chance to do it last night, we were at opposite ends of the dinner table. But I'll throw this out for consideration. There are a lot of New Deal statutes, and one that I happen to work with a great deal is the Federal Power Act, where the congressional delegation of authority is deliberately broad and very well stated. And anytime you run into a statute that uses the words any or all or every, right, that tends to eliminate ambiguity about the scope of what the agency is supposed to be doing. And so I venture a prediction. I had a friend of mine, Harvey Ryder, wrote an article about whether the major questions doctrine would have prevented some of the Federal Energy Regulatory Commission's landmark decisions, order number 888 for open access to transmission, the transmission facilities, or order 1000 about transmission planning and rates and cost allocation and stuff. And at the end of the day, when you pin that to statutory language in sections 205 and 206 of the Federal Power Act, those are incredibly broad grants of administrative authority. Now, counterpoint. Well, if you're going to sell that electricity, somebody's got to build all those power plants. Oh, well, we have to deal with the EPA. We have to deal with the National Environmental Policy Act. And there, I think you do start to run into questions about the extent of congressional delegation. It is not an accident that the EPA was a frequent target of the major questions doctrine, in my view, and I don't know that LOPR goes anywhere near resolving that issue. But that's that's a dichotomy for you, a little bit of a takeaway. I think if you have a New Deal statute with a broad congressional delegation of authority, LOPR doesn't mean very much. If you have a statute that was enacted anytime after 1970, that's the result of legislative sausage making, if you will, this LOPR will have more influence, I think, on outcomes. Roger?
No, I like what you said there about, courts, they're gonna do what they're gonna do. I have to admit, on writing even at a state level, helping with these decisions, you just lay out what sort of the background is, the sort of the cases that identify where to lead you to down a road. And then the judges do it, they're gonna decide on based on what they believe is the correct position and interpretation. I think I wanted to add that, what LOPR does not do. Maybe we can get.
Sure, yeah.
Because, I'll list a couple and that John follow up as well, because, it can be confusing, it's confusing enough for attorneys as, if you're not attorney, I guess it's just amusing. But one of the main things to me is that the agency interpretation of its own regulations is not included in LOPR. Agencies write their regulations and they're going to be given great deference in what those regulations mean. Agency fact findings, agency technical documents, they're going to be given a lot of deference on those. That's their job. It's their full-time job to find facts, do technical reviews. Those will, have to be based on substantial evidence, but they're not part of the LOPR decision. And John, I don't know if you want to add some other things about what does it not do? I mean, here things, and it gets to the question also is why should you care? What does it mean for you in your work world? But
It doesn't change the fundamental framework for judicial review that's laid out in the Administrative Procedure Act, of which Chevron was a small but notorious part, right? In terms of practical implications, I honestly, I hate to say this, but you may find judicial decision making at the higher levels simplified, but not having to go through the checklist that you had to go through in Chevron. There's a hilarious, and believe me when I say that one rarely encounters hilarity in Supreme Court opinions, but there is a hilarious exchange of judicial snark in LOPR, right, where Justice Roberts, for the majority, is bemoaning the fact, oh my God, there's all this complication has converted the Chevron two-step into a dizzying breakdance. Now, I have to say, if I was John Roberts' clerk, I would have said, don't go there, Judge. Don't go there because you got three snipers on the liberal wing of the court, each of whom is smarter than you are, and no, you don't know what a breakdance is. So, and sure enough, Justice Kagan had him right in the crosshairs. It says, Chevron was mostly a check the box exercise for judicial review. And if the majority thinks that's a dizzying breakdance, the majority needs to get out. Listen, Supreme Court decisions are dry as dust, and you have to take the humor where you find it. Okay, nobody's rolling in the aisles, but I thought it was kind of cute. So
that's good stuff. I would add to that, that, and I don't know if this is true or not, I read articles like everyone else, and people will be making more sophisticated arguments and law review pieces on LOPR and its aftermath, but I can't say how it wouldn't have a sort of a chilling effect on rulemaking as agencies, federal agencies, obviously, go to draft rules. I think they're going to have to look real closely obviously have the statutory authority, rather than just, going through the motions of, we'll just Chevron that and, get to see what the judge says.
Well, one of the other things is that the major questions doctrine, which evolved as a carve out from Chevron, has taken on a life of its own. And that's really not a corollary of local right, but it is something that's worth observing. It was only last Friday, I was sitting in the US Court of Appeals for the DC Circuit, watching arguments on the EPA's greenhouse gas rule, which there's another bit of arcana. I'll try to hit the highlights, but for those of you who don't follow that space, is an EPA rulemaking that says if you are going to be a coal plant in operation after 2036, you need to have 90% effective carbon capture and storage in place on your waste stream, your airstream coming out of your exhaust. And the industry, my industry, went nuts over this. One of the great points of convergence between my public power constituency and the investor on the side of the industry was, oh, no, you don't. Nobody has made carbon capture and storage work on a commercial scale. And you're telling us that we have to be able to do this in 12 years or stop operating on a coal plant. So the first thing that comes to mind, or comes to the brief writer's pen is, well, this is a major questions doctrine issue because you are in effect changing the way we generate power. So this is a replay of West Virginia versus EPA. And maybe it is. But I found it interesting that the bench, and it was a pretty diverse bench. One rate, what was it? No, trying to think. One Trump appointee, one Obama appointee, and one Biden appointee. Okay. The bench was less interested in deference or major questions doctrine than they were in the administrative record. What does this really prove about whether carbon capture and storage is a best system of emission reduction in terms of the Clean Air Act, Section 111? What's, EPA, what's your best case? And that argument on for 2.5 hours, right? Which is unusual. I mean, it was a big deal, but the court usually disposes of these things 15 minutes aside, 20 minutes aside, boom, you're done. Turn it over to the clerks will sort it out. This was a very lively inquiry, but it was completely divorced from any of the kinds of presumptions or ground rules, if you will, for administrative review, other than the very basic. You take a look at the record, you see whether the record supports the result. Is there a rational connection between the record and what you did? Now, I'm not sure what the takeaway on that is, other than that major questions is not a dead letter after local right. It's got more vitality than it ever had. So even though Chevron, to which it was supposed to be an exception, is dead and buried.
Yeah, that's a good point about major question, Doc. Honestly, I never given much thought until the decision came on. But it does sort of make sense, and I think John had in one of his slides, the obvious, Congress doesn't, or it shouldn't, be making major changes in law based on subtlety or nuanced language. And I just think, well, that's just common sense, that's an agency trying to find something to hang its hat on, and there's not much there, so they don't talk about it, they just kind of hope it just goes away.
Well, as you said, we'll just Chevron, to the extent that an administrative agency with an agenda can lay claim to a rationale. And this is, if you look at low for bright, this was well, the statutory hook was really like a necessary and proper clause, right? The National Marine Fisheries Administrator can do whatever is necessary and proper to enforce this statute. Well,
That's pretty broad.
yeah, but and in that sense, Loper's not, it's not a major questions doctrine case. It was strictly a question of deference, but,
Let me throw in a couple of more points that I wanted to make, the flip side of this is that the Trump administration will be just as bound to Loper as the Biden administration would, meaning, Trump was a guy who likes to make pretty dramatic comments about the changes he's gonna make on day one, and et cetera, et cetera. Well, that's not gonna happen. You gotta go through the Administrative Procedure Act to make these kind of changes. It's gonna be a long, slow grind for most of the things that he wants to accomplish. And I'll say this, because the other obvious thing, and I don't even see it in the media a lot, and maybe it's not true, maybe I think it's true, it's definitely true. The Trump administration obviously will have control of the Senate and the House. And control is the wrong word for the Supreme Court, but they have a favorable Supreme Court. Anything that the Republicans can agree on can be passed by law. You don't like PM 2.5 at level 9 for standard? Well, you could change it by statute to 12. And I know they must be thinking about this and whether or not they actually want to go that route, because it's just a legislative swath, and they can do that. And will they? Who knows? They are in a position to do virtually anything they want if you can get all the Republicans to agree, which is hard. And I just to use Missouri as a comparison to some degree, I used to lobby in the General Assembly, I don't anymore, but it's pretty clear that we have two Republican parties. We have sort of these mainstream Republicans still, more practical, trying to run government. And then you have guys who don't really want to run government. They just have these agenda issues they want to accomplish. And that's probably too harsh of a criticism, but it seems that way to me. And I don't know what the Democrats stand for at this point, but it makes it hard. And he's going to have that battle in Congress. Can he get unity on really making some huge changes, legislatively or not, or whatever. I mean, John, I'm sorry.
you're reminding me of one of my early heroes in Missouri, a guy by the name of John Black, who used to be the general counsel for city utilities of Springfield. I forget the context. We were talking about another Justice Scalia opinion, Allegheny Mac Sales and Service versus National Labor Relations Board. And I read the quote about recent decision making. And I said to Black, I said, yeah, it just goes to prove that Justice Scalia wasn't always wrong. Black draws himself up to his full 6'3", looks down at me and says, Mr. Coyle, here in southwestern Missouri, Justice Scalia is never wrong.
All right, we probably should open up to some questions if anyone has them. We'd be happy to take a stab at them. I do want to make one more comment, because earlier on I was saying one of the reasons that Chevron made sense to me was to sort of cut out venue shopping. And I think that might come back. Attorneys and companies will try to find a favorable jurisdiction on interpreting a statute, or that's bound to happen. That was one of the things Chevron mentioned to prevent. And if anyone has questions, Josh is out there as a microphone, or maybe he's not, but yeah, you are. So if anyone has a question, there we go.
Roger, do you have the opportunity to go to the EPA and say, we're gonna lower that? Have you done that?
Not yet.
Have you seen, how do you see the LOPA decision applying in state to the states? Have you seen anyone try to implicate it?
I guess it obviously does not apply. And so, the Supreme Court law, there's really this is what the case law of the Supreme Court is that there's significant deference. It's really more backward, it's a Skidmore thing. I'm sure they won't cite, Chevron anymore, but it's really, in my view, is gonna be, there'll be some fallout, because I think agencies in any place, including Missouri, they're gonna start looking at their statutory authority and write them better. They have to make sure they're,
I just add to Roger's comments, it's early innings yet. Chevron was never, imposed on state law. Various state Supreme Courts either adopted that mode of judicial review or didn't. And many were very kind of diffident about actually embracing Chevron to begin with, because the state's views of their own administrative procedures vary a great deal from state to state. If I was going to forecast it, I'd say local probably will not have a great deal of influence on state review of administrative agency decisions.
any other questions?
Sure, yeah, right over here.
I'll try to be loud, if folks agree. So there was a competing case to Chevron, which came about the same time, which, said that the 6-year statute of limitations for challenging administrative rules begins when the injury happens, not when the administrative rule comes into effect. So basically, any new entrant or any new entity that is impacted by the rule can challenge it now under the APA, where previously the 6-year, once the 6-year statute had run, you either have to violate the law or you have, in order to challenge it, or do you think that will have, or how big of an impact do you think that change in the law will have, as opposed to Chevron, which I kind of think just turns you back into a dueling experts kind of process, in court?
That's a great question. John and I were talking about that on the phone. And I've been talking about I work for a business association. We've been talking about that internally too. And I don't know that I have an answer. I don't know if John, you give it any more thought.
Well, I think,
You're talking about corn post.
yeah, corn post, yeah. And I do think that is a big paradigm shift for judicial review. The 6-year statute of limitations is a default statute of limitations under Title 28 of the United States Code. 28 U.S. Code 2401, for those of you who are still worried about your CLEs. Regulations, and again, ultimately gets bounced on standing grounds, and appropriately so. But those kinds of cases are waiting in the wings in a big way for people who, well, my 6 years hasn't run yet.
Well, in Missouri, when we have our own Administrative Procedure Act, and I don't know what the statute of limitations is for those. I assume I don't know if it's in the statute, in the regulation or statute or not. Not that I certainly have, or in the first place, I don't